Welcome back. I'm attorney Thomas Burton. I'm an estate planning and asset protection attorney here in Wisconsin. And welcome back to my Real Attorney Reacts series. Now, today's question is another question involving inherited property for a married couple. And again, we're going to analyze a question submitted to The Moneyist, a columnist for Market Watch. And here's the question. My father left me money for a house, and my husband put his name on the deed. How do I ensure it goes to our kids? When his mother passed away, he received an inheritance of $8,000. I was never told about this money, and he spent all of it. Dear Moneyist, I have been married to my husband for 38 years, and we have 3 children together. When his mother passed away, he received an inheritance of $8,000. My husband never told me about this money, and he spent all of it before I found out he even received his inheritance. When my father passed away, he intended that any inheritance we received would be kept in his own family. So naturally, my inheritance was made out to me and me alone. And I'll add an aside, that's quite common in most families. The inheritance wouldn't go to a spouse, it would follow the bloodline. I deposited the money into a checking account with just my name on it. So here I'm thinking, good, because if you inherit money in the state of Wisconsin, I'm going to analyze this question under Wisconsin law, where we have marital property, which is a form of community property. If you inherit property, it's considered individual property, even if you are married. However, the key is to keep that property separate from marital property if you want to avoid having it treated as marital property. So a good way to do that is open a separate bank account and put just the inherited money in that account. Don't mix it with marital assets such as your joint checking account. She continues, within 30 days of receiving my inheritance, I purchased a home with the proceeds, and my husband talked me into putting his name on the deed. The check given to the seller's attorney was a cashier's check with my name alone. If I die before my husband, is it possible to put the house into a living trust, given that my father's intent was to keep the money within the family and not my married husband's family? I want this home to be inheritance for our children, and I don't want him to sell it as soon as I die. I wish to make sure that he doesn't sell it out or rent it out in his lifetime. I would like him to live there until he dies. He has paid for a couple renovations on the home. How would I go about making sure that my kids will have this home as an inheritance, assuming I predecease my husband? Now, as a reminder, I find some of these questions dealing with estate planning and inheritance very instructive for our viewers, and I analyze them under Wisconsin law, where I am licensed to practice. The Moneyist is a national advice columnist who is not a lawyer but provides personal finance advice. So here's his response to the reader. What's his is his, and what's yours belongs to both of you. What happens to your property if you predecease your husband, which is obviously not a given, depends on the kind of ownership you share. If you have tenancy by entirety or joint tenancy with right of survivorship, then your husband will inherit your half of the home. If you have tenancy in common, then you will be able to bequest your half to someone else, in this case, your kids. And he's correct on that. So the key in her question is that she says her husband talked her into putting his name on the title. So what they're going to have to do is examine the actual deed and see how it reads. How do they hold title? Is it tenancy by entirety or joint tenancy with rights of survivorship? And in Wisconsin, we have a special way married couples can hold property called marital property. And you can write husband and wife as survivorship marital property. And that means it automatically passes to the surviving spouse upon death. Now, she doesn't say what state she's in, so I don't think it's Wisconsin. But the key here is she needs to check that deed very carefully, preferably with an attorney. So the Moneyist continues, if you had bought this property alone with the money you inherited from your father, it's typically deemed separate property in a community property state. And that's just what I was talking about earlier, about how in Wisconsin, inherited property is deemed individual property if you keep it separate. And he says in a community property state like Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. Inheritance is usually separate property. But if you use marital funds to improve the property, it becomes community or marital property. And he's correct there. The short answer is if you start mixing marital funds, like you use the joint checking account to pay the taxes and for improvements to the home, after a while we have what's called mixing occurs. And in Wisconsin, there's a presumption that all property is marital property if you can't trace it. So if you mix marital with individual property, after a while it becomes too difficult to trace, and if it's left to a judge, they're going to apply the presumption likely and say it's marital property, I can't trace it. That's why if you get individual property, you want to keep it totally separate so you can show it was the money you inherited from mother and then the money went to the house or however you do it. Or even better, I would put it in a separate trust to show that it came from your mother or father. It's all inherited property. Okay, so he continues, but it's different in a separate property state, in most cases where there are no extenuating circumstances. In a separate property state, one spouse can hold property without having the other spouse on the title, and the other spouse would not have any right to that property, says Kimberly Hanlon, co-founder of Lucier Legal in Minneapolis. So right next door here in Minnesota, next door to Wisconsin, they have separate property in Minnesota. In the case of a divorce, the court will sometimes look at the proportionate share of contribution when determining how to split up the asset, in which case her contribution in the initial purchase would be weighed against his contribution in the improvement. She adds, probate court also considers whether it's a separate asset, joint asset, and a prenuptial agreement can change it again. So remember when the questioner said she paid for it, but then the husband has paid for some improvement? To me, right away, that's a problem because it looks like mixing individual property with marital property. So you would want to keep that very clear. And if you're actually really worried about this, it would be better, in my opinion. It depends how much the husband contributed, but get his name off the title and maybe just give him the money back and get a signed statement to that effect so it's all your individual money that improved the property. And consider a marital property agreement. Like she says, you can sign an agreement where your husband agrees that it's not his property. That would be the safest, in my opinion. And then put this property inside a trust. You could do a revocable living trust with the right of the husband to live in the property for so long. But the trust could say it goes to your children. That means then when you pass, your husband's not on the title. He can't change the title after you're gone to a future spouse or spouse's children, for instance. So I would recommend looking at a trust and sitting down with a good lawyer in your state to discuss how to do it and make sure this property stays separate and goes to your children. Okay, the money continues. In some separate property states, the surviving spouse has statutory rights to a certain percentage of their deceased spouse's estate and or rights in the marital homestead. Hanlon says Minnesota is like that. However, the surviving spouse may consent to waive those rights either in advance while their spouse still lives or after death. So your husband, if he's living in the marital home, if you were in Minnesota, for example, work with a Minnesota lawyer, and you could have your husband agree to waive those rights if he did have any to the marital home, and you could do that in a marital property agreement. But the issue I see here is once she added the husband to the deed, she's going to have to get him to cooperate to do some of this stuff. So I would have, if I was her, I would not have added him to the deed. I understand it's her husband, and she says he talked her into it, but she should use now her power of persuasion and reasoning to get him off the deed and put it into the trust so that it isn't a problem for the children later. You don't say where you live, but your husband seemed to know what he was doing, not putting his name on the deed and using marital funds to renovate the home. So the he says not putting his name on the deed. I think he means putting his name on the deed. Because the wife says she added him to the deed. My husband talked me into putting his name on the deed. So I think the moneyist means that the husband talked her into putting his name on the deed after she basically bought the money with inherited money. And using marital funds to renovate the home. So he's saying maybe the husband sort of knew if we use these marital funds, it'll make it marital property, etc. by mixing. The good news is the opposite is also true if he predeceases you, but let's hope that doesn't happen and you have many more than your 38 years left. If you do receive another inheritance, don't let anyone talk you into anything. So I think that final advice is very true. Don't let someone talk you into doing something that you don't want to do. And she's going to have a few options here, which I laid out, but likely the safest from what I can see is you would want to retitle the house now, get it into a trust with the beneficiaries being only your children, possibly with the right for your husband to live there for a certain amount of time, as you said. And then to be extra safe, I would discuss with your estate planning attorney in your state signing a marital property agreement right now while the husband's alive, where he waives his right to any share in the home and agrees that it was her individual property. And if there is some, depending on the amount of money he contributed, there'd be a way to equalize back to him perhaps that money through some other method, such as through a bank account, a life insurance policy, retirement account proceeds, etc. So I would work it out, all of it ahead of time, get it all signed in ink by your husband while he's alive and both of you are of sound mind, so you can ensure this home passes to your children as intended. So this is a great illustration of the dangers of inherited property, what can happen if you don't keep it separate, and also the danger of letting anyone talk you into anything. Because once someone is on the deed, they have rights as an owner of the property. And in general, you want to keep control of property. So it would be better. I'm glad she's thinking about this now, but before the closing, I know a lot is going on, but it would have been better to talk with an attorney before she even put the husband on the deed and figured out how to do all this. It can all be rectified now. She's just going to have to take a few steps to do it. So I hope this article, I try to pick out articles that I feel will be illustrative for the viewers. And this one touched on a lot of issues with inherited property, marital property, houses, and living trusts. I hope it was helpful to you. Thanks for watching. If it was helpful, consider giving a like and subscribing so more people can see and benefit from this content as well. Thanks for watching, and we'll see you next time.